is what happens if someone doesn't have a will in place? Or
Well, not having a will creates such a complex situation, because
have you ever thought about how to avoid conflicts over your property after you're gone? Or wondered about a complicated family situation like, what if there is a divorce? How can I make sure that my assets go to the people I want without any unnecessary complications or legal challenges? These are concerns a lot of us actually have but never really address. But in today's episode, we tackle these questions head on. We'll explore how to create clarity and avoid conflicts through proper estate planning. Joining us today is Patricia Galea, Principal Solicitor at Galea Faustin Solicitors here in Melbourne. Patricia will guide us through the steps that we can take to make sure that your wishes are honored, your loved ones are protected, and your legacy is preserved. So if you want to make sure that you leave behind a legacy of love and not legal battles, you cannot miss this episode. Patricia, thank you so much for joining us today. I'm so excited to have you over.
My pleasure. It's always a pleasure to collaborate with you, Pri.
Thank you so much. But as I mentioned, that today we want to understand everything estate planning. Let's start with the basics, Patricia. What is estate planning? I know it's wills, powers of attorney. Can you break it down for us and help us understand it a bit better?
Absolutely. So what is estate planning? Estate planning is actually drafting documents such as a will, an enduring power of attorney for financial and non-financial, and also a medical decision treatment maker. So What is a will? Well,
if I die, this is my list that my home should go to my children and things like that. Is that a basic understanding of it? Or?
Absolutely. So a will actually encompasses what your wishes are in regards to the valuable things that you have acquired during your working and non-working life. Sure. For example, your home, if you have shares, if you have a car, then you want to ascertain that those items go to the right person. So let's say, for example, if the home you intend to gift it to your children, then we also need to assess whether a simple will is enough to encompass this, or do you want this to be put in a testamentary trust, which is a document higher up than a will that provides a vehicle to protect your assets against any third parties. For example, if your children are going to get married and there is a breakdown in their marriage, you wouldn't want them, their partners, to actually inherit from your hard work. So then a testamentary trust can be the appropriate vehicle to encompass your wishes.
Right, okay. I never thought about it because I actually stopped thinking at my children, but never thought that I had to go a step beyond. And what if something happens in their personal life and I can actually protect my assets against that?
Absolutely,
right, okay,
absolutely. And for example, too, so if you want to leave a legacy for your grandchildren, because let's say something happens to one of your children, and you want, and they have a family of their own, then you want to be able to think that these little people may need some financial assistance from your estate. So a will can also encompass those wishes.
Right, it's so detailed.
Absolutely.
And so you would actually help us think through all these scenarios and put it all together.
Definitely. Like I advise on really complex situations. I get families that are recomposed. So, they had children from previous marriages, and then they come together and they're like, well, how do we deal with our estate now? Then we walk through the steps as to what we can put in place to keep everyone happy, because you don't want a legal dispute, a legal battle to arise out of your estate, because it's very costly.
Sure. So for example, everything's hunky-dory now, there's no complications, we can put together something simple, and can we change it over time?
Absolutely. So a will can be changed. So it can be changed with life circumstances. So for example, if you end up having more children, or if your children end up, married and having their own children, then, you can change your will to encompass those new situations.
Sure.
Yes.
So do we have to review it regularly, or only something changes in the family structure, or is that something that you recommend that we review it?
I say that a will is your life story. So every time that there is a significant change in circumstances, or let's say you sell a home, you buy another home, you buy 10 other properties, you want to be able to encompass this new life story in your testament.
I like that will is a life story.
It is, absolutely.
Actually, so beautifully brings it all together.
Absolutely.
So, that's great. And a lot of people are confused between wills and powers of attorney. And you also mentioned the medical
treatment decision maker.
So if you can maybe explain what the difference between power of attorneys and then also the medical.
Absolutely. So a will takes effect after you have passed away.
Right.
Whereas an enduring power of attorney provides powers to people that you entrust to make financial and non-financial decisions on your behalf at the time that you have lost capacity. So for example, you get people that suffer from dementia, from Alzheimer, Parkinson. These people have lost mental capacity to make financial and non-financial. Then having this document in place will allow, for example, your wife, your husband to make financial and non-financial decisions on your behalf. For example, if let's say in your power of attorney you say you want to be taken care of at home and not placed in an aged care facility, then the person that has power of attorney needs to honor those wishes to make sure that during your lifetime that your wishes are respected. And for example, if let's say you need to sell your home and go into an aged care facility, but you don't have mental capacity to actually sign the contract of sale, the power of attorney will allow the person that you have given those powers to sign on your behalf. And medical treatment decision maker is, let's say you suffer from a terrible disease and you need to be resuscitated or placed on life support, or you need to receive life prolonging medical treatment such as tube feeding. Then a medical treatment decision maker allows you to provide directives to decision makers as to what your wishes would have been in that case. Like I get clients saying, look, I don't wish to be resuscitated if I am going to be in a vegetative state. Then it's included in the medical treatment decision maker that this person, if a medical team deems that if she's resuscitated, she's just going to be a vegetable, then no, let her go, then the decision maker need to respect this. Yes.
But that's great. Thanks for clarifying that. But what happens? Does it not default to the family member? If someone did not have a power of attorney or the medical treatment decision making, does it not mean the surviving partner or the children by default take those decisions?
Absolutely. Well, but then there can be dispute as to what one child can say, well, I want mom to remain on life support. The other child may say, no, mom is suffering. Even if she's on life support, she's suffering. I want her to go. Then how do you define the situation if every person has different point of views? So this is why it's important to have those documents in place, because in situations like those, people are going through a lot of emotional stress, through a lot of emotions, and having those prescriptive documents will actually alleviate the responsibility.
It'll actually create such stability and peace when,
absolutely,
especially at a crisis like this, the least thing that you want is have quarrels and conflicts in the family.
Absolutely. Or think, what would my parent would have liked at this stage? And that's a massive responsibility to take. Whereas if you have those prescriptive documents, you are doing exactly what your loved one wanted you to do in that situation.
That's great. Thank you so much for clarifying that. The other question that I had, which is a very common question, is what happens if someone doesn't have a will in place, or if they die and they didn't have a will in place? Does that mean that their family inherits everything by default or no?
Well, not having a will, it's creates such a complex situation, because dying without a will means that you're dying intestate. When you die intestate, you have the Victorian laws, because we're in Victoria, I'm going to focus on Victoria. You have the Victorian legislation actually dictating how your estate should be dispensed. Right. So, and for one example, I had a client, they never got divorced, but separated from their long-term partner.
Sure.
They had been separated for 20 years, no contact with each other, nothing. But legally, that partner is still their spouse. So when he died without a will, because he didn't have mental capacity at the time that it was necessary to make a will. So he died without a will. So then the wife with whom he hadn't had any contact over 20 years became the beneficiary of his estate instead of his children. His children were looking after him throughout his lifetime, throughout his illness, but they didn't get anything out of the estate. And the mother got everything, and she was estranged from the children too, and she didn't give anything to the children. So that is one of the risks that you face when you don't have a will or when you don't update a will. And you also need to take into consideration that if you have had a will before marriage, and your will doesn't say that this will has been made in contemplation of marriage, as soon as you get married, your will invalidates itself. So it's no longer current.
Right. So marriage is one situation that will need to be factored
Exactly,
in.
absolutely, because marriage invalidates your previous will. So then you will have to ensure that you update your will to capture the new situation that now you're a married person.
Okay, right. So does that mean that the partner normally defaults? If there is no will, the surviving partner defaults the inheritance of everything?
Absolutely, it does. But let's say that you have children from a former marriage and you don't have a will, so your current partner will get most of the estate, and then there is only a small portion allocated under the State Act, to your children from your previous marriage. So then that causes tension.
Sure.
Because,
Absolutely.
There you are as children of your parent,
Exactly.
not inheriting from the hard work of your parent.
And who knows what that person wants. So, and he's the one who owns it, who's created everything.
Absolutely.
And the last thing he would want is to at least be distributed the way
he would like it. Absolutely. And I see situation like recently to you see that people are dying younger and younger.
Yep.
So for example, I have a client who was 46 years old, died without a will, leaving 3 children. And his eldest child is actually 18. So he was a father quite young, became a father quite young. So 18 years old, father has died. The father and the mother of the children were divorced. So who automatically becomes the administrator of the estate is that 18-year-old child, who has no financial acumen, no legal acumen, no life experience, but has to deal with SMSF, has to deal with properties interstate. But if the father had a will, he could have appointed someone with more experience, such as his own mother or his own siblings, to look after the estate, not having this 18-year-old now sitting in my office asking me, what do I do? What does that mean? What am I signing? You're 18 years old. You just finished high school.
Yes,
what
absolutely.
do you know? Yeah.
And
so
again,
important.
What happens if someone dies overseas as well? That could be another complicated scenario, or is it?
So, what do you mean if they have assets overseas?
If they have assets overseas, yes, that's one.
Yes.
And if they die overseas as well, so they're Australian citizens. Like I am an immigrant, so I'm from India originally. And again, what if I go there and something happens to me, and if I die, I have assets in India and I have assets here, and I may not have a will. So
absolutely. So that adds a layer of complication in the sense that normally you need to have a will in each country that you own assets.
Oh, really?
Yes, it's advisable. Unless the country where you own asset is part of the Hague Document Convention, meaning that whatever document has been created in XYZ country and we are in the Hague Convention countries, then it's recognized here in Australia. But I always recommend people, you have wills in the countries that you own assets. But then, yes, if you have passed away intestate without a will whilst being overseas, and let's say you don't have anyone here to look after your affairs, goodness me, then we have someone from, let's say, for example, India having to apply for a tourist visa to come here to try to manage your affairs. It's chaotic. And because that person there, of course, from India, Australia, they have no knowledge of how the legal system works.
And probably my partner would still default to...
Oh, yes. So if you have a partner here, absolutely, your partner will still inherit from your assets here. Sure. But of course, if it's a straightforward situation, all hunky-dory. But if it's not a straightforward situation, then the layer of complications just enlarges itself.
Right, okay. And one of the questions that I've had from some of my clients is, what if they have a will, what do they... Like, a lot of them have been looking at getting wills done online and everything. Firstly, tell me about that. Like, is that advisable?
It's not. Why? At the moment, we are actually going through litigation for a will that had been drafted from, this post office kit, drafted, and there is a comma that changes the entire significance of the will. So then you have beneficiaries fighting each other because one is interpreting it as A and the other is interpreting it as B. So then we are in court trying to decipher what are the wishes of a testator. So if it was drafted by a proper solicitor, these things, can be picked up very easily, and we have to go through free fine comb to make sure that the wishes are what the testators wanted. But if you do it by yourself, you have a comma or a dot somewhere, it changes the meaning of the will, and that can be very costly.
I can totally relate to that. I've been teaching punctuations to my children lately, and I keep telling them, see, if you don't put this comma, see, it changes. I've been explaining them and this sentences that we go through every day, so I can relate to that. I was like, punctuations are so important.
Absolutely. And now, we're hundreds of thousands of dollars deep into proceedings to try to decipher what the testator's wishes were.
I agree to that. Like, having the right professional help for these matters is so crucial. Like, you probably may end up saving a couple of $100s, but look at what's at stake.
What's at stake, exactly. You are depleting your estate, going through battle, when if this will was drafted properly, you would have gone your separate ways with a nice chunk of inheritance.
Absolutely. I'm completely in agreement with that.
Gosh. And people will be like, oh no, it's expensive. No, it's not expensive. In the scheme of things, it's not expensive.
And I've got mine done as well. So I know it's not expensive. Thank you for helping me with that.
My pleasure.
And now I know that my two children are not going to fight over the estate. They know what's going to happen.
Absolutely.
So thank you for that.
My pleasure.
But again, tell me, once we have the will, do we have to lodge it with some state authorities or any legal authorities, or is it just a document I keep it to myself?
So you can actually have it lodged with the Supreme Court, so they can keep the will for you. But of course, there is a fee associated with it. Or you keep it with the lawyer that has drafted it, like we have a safe. So most lawyers have a safe and they keep the will in a safe for you. But it is also important to inform your executors as to where your will is, because, if you pass away and you haven't informed them that you actually have a will, then it becomes a costly exercise to try find out whether you actually made a will or not.
Right.
So it's important to have this transparent communication with your executors.
And the family members?
Absolutely. And your executor normally is a family member, unless you don't have close family members, and it becomes friends. So it's important that you choose the right executor so you can have those candid communication with them, saying, my will is stored there. If I pass away, I want you to know, I want to be cremated, I want my ashes to be scattered, XYZ, and I want you to know this is my list of assets. But I normally keep list of assets and all that stuff on our file so that I can also help the executor at the time that they need it.
Sure. And coming to the executor, so the executor is the person who's responsible for honoring everything that's mentioned in the will.
Absolutely. So we have a crucial role to ensure that your wishes are respected to the dot and to the T. So it's a massive responsibility, and not honoring those responsibilities can have legal repercussions. So this is why it is also very important that you choose someone that you can entrust, that you choose someone that understands your vision, that you choose someone that understands your values. Because in a will also, if you have young children, you need to be appointing guardians. So because let's say my husband and I, we both pass away at the same time, then I need to ensure that I have someone nominated in my will that are going to be providing the same values that I provide to my children. So these roles are key. So this is why it's important to make a proper assessment as to who you appoint in those circumstances.
And that executor may not be a beneficiary on the will, right?
An executor can actually be a beneficiary, but I do not recommend it because, of course, it may create a conflict of interest. So I always recommend to people that, let's say, for example, you don't have anyone to be an executor for you. We are happy to step in and ensure that all your wishes in your will are actually carried on. So that alleviates stress for the client too, trying to find, oh gosh, this son is going to be a beneficiary and also an executor. What if he takes all his time? So to avoid this, I am happy to step in and help.
And that helps because you're, as a neutral party, they'd be actually doing the job more fairly. And
definitely. Absolutely. Yes.
Sure. Great. Thank you for clarifying that.
Pleasure.
And let me go through my list of questions which I had from my clients that they wanted to make sure that I ask. So I make sure I don't miss out on anything. So one was that how can people ensure their will is clear and avoid disputes among beneficiaries?
So it's important that it's drafted by a professional. Because the language in a will is different from the language of a layperson. So a will can be quite legalese, and we are trained to write in a legalese way. Legalese way in the sense that for the court to approve the document as a legal document, it has to have specific wording used. So it's important that you use a professional. It's also important that you have candid communications with your beneficiaries. For example, if you have decided to leave all your jewelry to X-child and none for the other, it's important to sit them down and explain that, look, I am leaving all my jewelry to my daughter because she's going to use it. She's my daughter. As my son, you won't be using my rings, you won't be using my chains. So it's important that you let them understand why there is a disparity. And also I encourage people to write letters of wishes. For example, I have clients coming in saying to me, well, I want to leave more to my daughter compared to my son because my daughter has always been, through my illnesses, through my periods of vulnerability, she has always been by my side. Then I said, look, this is going to cause massive disputes. Unless you have those clear communications with both of them to ensure that they are not going to be contesting the will, it is also important that we back this with a letter of wishes as to why what you're providing in the will, there is a disparity between A and B. So those letter of wishes have massive legal weight in the event there is a dispute down the track.
That's good to know that there is an option like that, and that actually clarifies why what has been done.
Yes, absolutely. Or for some people that are completely eradicating one child because they haven't had contact with that child for 20, 30 40 years, which I recently had that for a couple. They had only one son and they hadn't spoken to their son over 30 years now. So we don't even know where he is. So then we have had to write a letter of wishes as to what the history of the relationship was and what has occurred that they don't even have any bond. So if you're not leaving anything to the child because you don't even know where he is, you're not part of his life. So then those letter of wishes will reinforce the situation in the event the child comes out of the woods when the parents have passed away and say, oh, well, now I'm inheriting everything. No, you're not. And that's because of,
there's legal proof.
Exactly. Yes.
No, that's right. And can we appoint people overseas? So I have a lot of my family who live out of Australia. Can they be part of the will as well, or are there any restrictions?
No, absolutely. So you can appoint beneficiaries all over the world. So if you have nieces in Canada, and you're based in Australia, have nieces in Nepal or wherever, you are able to appoint any beneficiaries. But I recommend that you appoint executors that is local to the place where your will has been drafted, because it's going to be hard regarding visa issues, or if you have to be on ground, that's going to be very hard.
I guess it's the practical side of things rather than, it's not a rule, but practically
exactly, definitely.
Yes. Perfect, great. Thank you for that.
That's okay.
And this one's an important one, which I also had a question. So for parents, what steps should they take in their will to protect their children and secure their future? So I think you briefly mentioned about guardians. Can you just explain a little bit on that?
Absolutely. So guardians, their role is primarily to ensure that your children are taken care of up to the age of 18 years old. Because let's say, for example, my husband and I both die in an accident. I have an 8-year-old and I have a 16-month-old. So then I need to ensure that there is someone in my will that can step in and take the parent role to manage the estate for my children, to manage their day-to-day living, to manage their upbringing. So that's the role of a guardian. But let's say that your children got married and you can see that one of the partners is a bit difficult, and you can foresee that this is not going to go anywhere. So then you can ensure that all your assets are held in a trust, and then you have a testamentary trust actually controlling how the assets is going to be passed on. So for example, let's say in your testamentary trust, you can say that your son is going to be inheriting $1,000 per week, and that's exclusively for him. So by doing this, by putting these means and methods in place, you can then reduce the ability of a spouse to actually make a claim against your child's entitlement of inheritance.
Right. Yes. Okay, great. Thank you for that. I think so testamentary trust, we could still have it, right? We don't have to think about those situations. Only if something happens, I'll create a trust. I can still
you can still have
it just for safety purposes. Absolutely.
It's a good vehicle for tax, tax reduction too. So it's a good vehicle for that. So, and also if you want the asset to remain in the lineal family, so it's another good vehicle for that. So yes, it doesn't need to be all grim for you to have something like that in place. Okay, yes.
And as my role as an insurance advisor, we obviously get the clients to do beneficiary nominations on their policies and everything, which is good. But does that nomination also form part of the will, or?
So we need to make sure that the nomination is non-lapsing. So if you do a non-lapsing binding nomination, then that's completely fine. But if you do the one that lapses every 3 years, which some superannuation just allows people to do it every 3 years, then you leave it open to the trustee to decide who has the best or better standing to inherit from XYZ policy. For example, for superannuation, I've just faced this issue just recently. So the lapsing binding death nomination had lapsed Okay, so that person was quite young, so 37 years old, had up in his previous nomination, had appointed his brother to be his beneficiary.
Sure.
But then when he passed away and we made a claim, the trustee decided that no, the brother doesn't have a better standing, that they wanted the superannuation to go to the parents. And the parents didn't want that because they had received advice that it would affect some sort of pension and things like that.
Yeah.
So they didn't want that to happen. But unfortunately, the trustee had said, we had made an appeal and everything. The trustee said, no, that's our final decision. The better standing is the parents, not the brother. So this is why it's very important when you update your documents and that you become an advocate for yourself, that you want those documents to be non-lapsing.
Right, okay,
Yes.
sure. So I think we were talking about the beneficiaries, especially the ones in super. Is that, do we have binding nominations or non-binding in super, or is it both? Do we know?
So some super funds actually do provide non-lapsing binding death nomination, where you can, nominate your beneficiaries and it doesn't lapse.
Right.
Whereas there are other super funds where they provide you with the one that lapses every 3 years. So then every 3 years you need to be updating your beneficiaries.
And if you don't, there is
then
nothing
if you
there.
don't, then you have a trustee making a decision as to who has better and proper standing to actually receive your super fund. So, and the example that I give is we had this young boy that had passed away at 37 years old, and his previous nomination was always his brother, but at the time of his passing, it had lapsed, and the super fund actually refused the brother as having better standing and provided the super fund to the parents. And the parents didn't want that because they had received advice that may affect their pension.
Yeah.
So then, even despite appealing this decision, the trustee remained on their position that no, better standing are the parents.
That's
instead
so
of
strange.
exactly.
They'll actually not take the family's wishes into consideration.
No, they don't, because a super fund is separate. It's a separate entity. It's, whilst yes, it is yours, it is managed by a trustee, and that trustee makes decision as he or she sees fit.
Right.
So yes.
And is it a matter of asking the super fund, can I make a binding non-lapsing nomination, or?
Like I say to my clients, be the best advocate for yourself.
Sure.
And ensure that you press on that you want a non-lapsing binding determination. And if they don't have the required documents for it, you're happy to actually engage a lawyer to create that and file it with them. But you do get a lot of pushbacks.
With the super fund.
With the super fund, absolutely.
Okay.
Yes.
But doesn't harm in asking.
Absolutely.
So I definitely recommend.
Exactly. Be the best advocates that you can be for yourself. Yes.
Great. And with the coming back to the nomination of beneficiaries in the insurance side of world, where the insurance is held outside the super fund and they have nominated the beneficiaries, but a lot of times I get asked by my clients that, okay, I have my wife and my children nominated, but my children is, one of them is 6, one of them is 8, and what if me and my wife both pass away? What would happen? And I tell them that, you can only do this much with a beneficiary nomination. You will need a will to support those sort of wishes. Would that be right when I say that?
Absolutely, because your will reinforce, is a vehicle to whatever policy that you may have outside of the will. So if you reinforce that, in the event that my spouse predeceases me, I want XYZ to go to my children, but I want them to start inheriting or managing their inheritance as of the age of 30.
Sure. Which
of course I recommend clients that they actually put an age of majority for young people to start managing their inheritance. And I find it irresponsible of people to just say, oh well, at 18 I'm not around anyway, just let the 18-year-old manage. No, we don't have financial acumen at that age. Their brain is not fully formed at that age. So,
and it's a big sort of a responsibility to put on an 18-year-old.
Inheriting millions of dollars. What does he do? He goes clubbing and splurges on alcohol. So no, you don't want that. So so then, of course, as a legal practitioner, I need to give a practical aspect of those wishes.
Okay, yes. Great. So now I think I would, and I certainly do recommend a lot of my clients, and I would keep pushing them that they know, although they're making these nominations, it's not the end of the. They do need to take that,
reinforce it absolutely with a will.
Yes. Now, great. And lastly, do you have any key takeaways, Patricia, for the listeners to know about the importance of wills and powers of attorney?
Absolutely. I say don't wait too long. There is this myth where people say, I am too young to make a will.
Yeah.
No, you're not too young to make a will. Even as soon as you're 18 years old and you are saving for your first house, or you've bought your first house, you need to start putting your estate planning in place. And you also have some people that have this belief that, oh, well, I'm in good health now. Why do I need a power of attorney? Well, when you won't be in good health and you won't be able to give me instructions to draft a power of attorney for you, then you know what I need to be doing? I need to be going to VCAT and assist the decision maker to apply for guardianship and administration so that they can make decisions on your behalf. And that's a protracted process. Whereas you pay $220 for a power of attorney and it's done.
And that's it.
It's done.
Yep.
It's in place.
That's so important.
Absolutely.
And one more question that I get is it only for the wealthy people? I just have one property. I don't need a will. Is that?
Oh gosh.
I get that so much.
Exactly. It's if I had to take $1 from everybody that actually said something like that, I would be driving a Rolls Royce today. Absolutely. I'll be driving a Rolls Royce, because there is this myth that, oh, I own none. I just own a home, or I just own a car and some savings.
Yeah.
But that's still a personal possession that you want to bequeath to XYZ member. So it's important to have everything like this encompassed in your will.
Absolutely. Yes. I can vouch for that. So thank you so much for sharing that, Patricia.
Really
appreciate your great insights and valuable tips. Thank you so much.
My pleasure. It's always a pleasure, Pri.
Thank you. Thank you for tuning into today's episode, and I hope you found the advice and insights as valuable as I did. I'd love to hear your thoughts as well, what resonated with you, or what would you like to hear more about in the future episodes. So please share your thoughts below. Until next time, keep learning, keep growing, and let's level up together.